Well, good morning. I'm Jagendra Rana. Topic for our discussion today is insurance needs under RERA. Insurance needs under RERA. RERA means RERA. So, after 9 years of long wait, the regulation of real estate sector across India became concrete. A reality with effect from May 1st, 2017, with the Real Estate Regulation and Development Act 2016 came into force under August auspices of Government of India. So the key objectives of this act are ensuring transparency and efficiency in real estate sector in respect of sale of plot, apartment, building or real estate project, protecting interests of consumers in real estate sector, establishing educating mechanism for speedy dispute redressal, establishing appellate tribunal to hear appeals from decisions, directives or orders of real estate regulatory authority. So under this act, state governments are expected to establish in their respective state real estate regulatory authority for regulations and promotions of real estate sector. Consequently, state governments will promulgate requisite notifications, rules and regulations. So this act is a necessary step towards reforming real estate sector in India, encouraging greater transparency, citizen centricity, accountability and financial discipline. Although RERA is a central law, RERA is a central law. Its onerous implementation will depend greatly on state governments as real estate is a state subject. Real estate is a state subject. So a proposed Gazette of India notification number at 1216 dated April 19, 2017 of Ministry of Housing and Urban Property Alleviation, New Delhi, an exercise of powers conferred under subsection 3, Real Estate Regulations and Development Act 2016. The central government has appointed May 1, 2017. On May 1, 2017, the following provisions of said act have come into force, that is section 3 to 9, section 40, 59 to 70 and section 79 to 80. But accordingly, provisions of section 16 pertaining to obligations of promoters regarding insurance of real estate projects has come into force with effect from May 1st, 2017. Now what this section 16 is? This provision says these obligations of promoter regarding insurance of real estate project. There is a specific section in this act which says there is an obligation of promoter regarding insurance of real estate projects. So what is this provision? Promoters shall obtain all such insurances as may be notified by appropriate government, including but not limited to insurance in respect of title of land and building as a part of real estate project and construction of real estate project. So promoters shall be liable to pay premium and charges in respect to of insurance specified in subsection 1 and shall pay the same before transferring insurance to associations of LOTs. Insurance as specified under subsection 1 shall stand transferred to benefit of LOTs or association of LOTs as the case may be. So at time of promoter entering into an agreement for sale with LOT. So on promotion or say on formation of association of LOTs, all documents relating to insurance specified under subsection 1 shall be handed over to association of LOTs. The promoter has to obtain all such insurance as notified by state government. So insurance will be compulsory only after notifications are issued by the state government. So the Act states that the state government can prescribe various types of insurances. It is imperative and pertinent that Indian insurance industry or the Indian insurance sector will have to accept the challenge and rise to the occasion in good time to devise and frame appropriate package or umbrella coverage to afford adequate insurance protection against concerned anatomy areas and risk exposure including title, warranty, design fault, structure defect, faulty or bad workmanship, inferior materials, machinery work, negligence, non-adherence to statutory and regulatory codes of practice by promoters and the like. So it means there is an act called Real Estate Regulation and Development Act 2016, which came into force from May 1st, 2017, with an object that it will ensure transparency and efficiency in real estate sector in respect of sale of plot, apartment, building, or real estate projects, because it has to protect the interest of consumers in real estate sector. It has to establish educating mechanism for speedy dispute redressal and also establish appellate tribunal to hear appeals from the decisions, directions or orders of the real estate regulatory authority. So under this act, the state governments are expected to establish in their respective state real estate regulatory authority. State governments are expected to establish in their respective states. RERA means Real Estate Regulatory Authority, RERA, Real Estate Regulatory Authority, for regulations and promotion of real estate sector. So consequently, the state governments will promulgate requisite notifications, rules and regulations. But this act is a necessary step toward reforming real estate sector in India, encouraging greater transparency, citizen centricity, accountability, and even financial discipline. So the RERA is a central law. Its onerous implementation will greatly depend on state governments, as real estate is a state subject. So this real estate regulatory authority has to be established by the respective states, because gazette notification is there. And under the provisions of this act, one specific section, that is section 60, relates to the obligation of promoters regarding insurance of real estate project. This section is very important from the insurance point of view. because this section binds promoters to obtain all such insurances as may be notified by appropriate government, including but not limited to insurance in respect of title of land and building as a part of real estate project and construction of real estate project. That means under section 16, promoters are liable to pay premium and charges in respect of insurance specified in subsection 1 and shall pay the same before transferring insurance to association of LOTs. So this is binding under this section 16. And thirdly, insurance as specified under subsection 1 shall stand transferred to benefit of LOTs or association of LOTs as the case may be. So at time of promoter entering into an agreement for sale with LOT. Further, on promotion of association of LOTs, all documents relating to insurance specified under subsection 1 shall be handed over to association of LOTs. So this section 16 binds promoters to obtain all such insurances as notified by state government. So insurance will be compulsory only after notifications are issued by the state government. That means the Act states that the state government can prescribe various type of insurance. Purposes are different because various purposes are there. A state government can prescribe various type of insurance. They can direct the insurance companies to frame appropriate package or umbrella coverage to afford adequate insurance protection against concerned anatomy, areas and risk exposures. What are the kind of risks related to the properties or a real estate? These are also defined. The risks includes title, warranty, design fault, structural defect, faulty or bad workmanship, inferior materials, inferior masonry works, negligence, non-adherence to the statutory and regulatory codes of practice by promoter and the like. So these are also defined under section 16 of the Act. Last but not the least, it will augur well if end users benefit from enhanced diligence and eternal vigilance of all stakeholders. Thank you. Thank you very much.